Okay, I'd like to welcome everybody to the meeting. Thank you very much for attending, and all those who are listening at the moment live or later on the recording. This is the Licensing and Public Protection Committee meeting, and at the moment we have a number of apologies. If we go to item 1, Councillor Wright, Councillor Whitmore, Councillor Sweeney, Councillor Orwell, and Councillor Johnson have given their apologies. But there are substitutions for Councillor Sweeney. We have Councillor Andrew Parker, and for Councillor Johnson we have Councillor David Hutchison. Move to the second item on the agenda, declarations of interest in relation to licensing matters. Are there any declarations? No, thank you. We go to item 3, which is pages 3 to 6 in your back, and the minutes of the previous meeting. Would you like to confirm that they are a true and accurate record, or are there any comments to make? Okay, thank you. So we now move on to the business proper, the Public Protection Committee. First of all, declarations of interest in relation to public protection matters. No further declarations. And item 5 of the agenda, which covers pages 7 to 64 of your pack, is the guidance on suitability report, which is a consultation. Matt, would you like to brief us on that, please?
Yes, thank you, Chair. Good evening, everyone. This report is in relation to the suitability guidelines as it states, which is the section within our policy where we have starting point when we're looking at people entering or within the taxi agents, whether they are suitable or remain suitable. So I'll go through a bit of the history as to how that's come about and just explain what we're asking for today. In 2018, the Institute of Licensing created some suitability guidelines, and the aim of that was to try and create an adoption across the UK really, and standardising suitability across local authorities. As you well know, every single local authority has their own policy, and decision making can be completely different from one local authority to another, and there is an issue nationally, or has been previously, of licence shopping, where someone may not be suitable in one city area or council area, but they might get licensed elsewhere. So that was the sort of starting point as to why it was introduced. So that came out in April 2018. In November 2019, when we adopted our substantive policy that we have at the moment, we incorporated those suitability guidelines into our council policy. Then in 2020, the Department for Transport issued the first taxi statutory standards. Effectively, what they did was they lifted that section out of the suitability guidelines and put it into statutory guidance. So it was thought of a sort of high regard as to something that the policy should really be using, because it's now in statutory standards and not just something that can be adopted. In theory, all local authorities will be acting either in line with that guidance or very close to it, unless there's a reason to depart from it. In 2022, the Institute decided to undertake a review of suitability guidelines. It's been 4 years since its creation, and they carried out an informal consultation which went out to local authorities and to some stakeholders. 114 responses received, including one from ourselves, and they have reviewed and considered all of those when they have produced the documents before you today as Appendix A, which is the draft updated version of these suitability guidelines. So what they're doing now is, with this draft document, is they've opened a consultation. It opened on the 10th of July, posted on the 30th of September. You'll see Appendix B, which I'll go through in a moment, is the officer's view in terms of responding to that, which we would like to be endorsed by members by this committee. And just to do that, once we've finished the recommendations, just note the contents and prove that we send the consultation as it meant to be. So just briefly, there are 4 chapters within the guidance documents or guidelines documents. First one is an introduction as to what the guidelines mean and purpose is. That's not been changed really since its first iteration, so we've not offered any comments on that at all. The second chapter is around offenders, offending, reoffending, and the risk of harm. An overview of that. This chapter has been extensively reviewed and has been looked at by professional in criminology and focuses a lot on the offending habits and reoffending habits, rehabilitation of sort of violent offenders and sexual offenders. In terms of the comments that we've made, they are limited. We've said that one of the paragraphs which relates to footnotes, it refers to a study. It says a general rehabilitation period for a non-violent or sexual offence is around 7 years. And in the chapter 4 section, which it gives timescales for some areas where it's just 5 years as a suitable rehabilitation period, which it's the same as what's in the 2018 guidelines. But there isn't a reason given as to why there's that differentiation. So we've asked for a reason behind the difference in the timescales. Chapter 3 is taxi licensing overview. It provides the sort of the legal background of taxis, private hire, the trade. It has been updated primarily for 2 reasons. One, that there is that Department of Transport statutory guidance that came out in 2020 that wasn't present when the first document was published. So it makes reference to that and a certain section of that. And it also now makes reference to the mandatory NR3S register, which is the National Register of Revocation, Refusal and Suspensions. When the guidance came out originally, it was around the time of launch as a voluntary register. In 2022, as you know, it became a mandatory register that local authorities had to use when checking taxi drivers and record decisions made against taxi drivers. Again, that was around in 2018. Doesn't include information about that. In terms of the officer's response, we believe there's a couple of typos. One of the footnotes has the typo needs amending. There's a request for some clarification around the NR3S register, because it is mandatory in England, and it alludes to it not being. And there's also a reference to carrying out criminal records checks from people who've been overseas for a period of time, which has been in both the statutory standards and in our policy for a while, but they're proposing quite a different timescale. So if they've been out of the UK for a period of 12 months within a 10-year period, they would suggest that we need to do a check. Again, we're asking for the reasoning behind that. It's not that we disagree necessarily. No explanation given as to what that is. There are different timescales and different sort of best practice guidance that circulates as well. So it'd be interesting to know why they've excuse me, why they landed on that time frame. Then chapter 4, which is the main one, the guidance on determination. So the section, this chapter in the 2018 document is what we have adopted in our council policy. That's what we use when we make decisions against those entering or those within the taxi trade currently. It has been amended quite a lot. It was the focus of the consultation exercise that happened in 2022 as well. So I'll give you a brief sort of overview of what the changes have been and what's been added in, which is essentially what we've said in that response. So some categories have been expanded beyond what they were previously. So the offensive violence category now deals with the fear of violence, for example, and the sex and indecency offences section now includes references to the sex offenders register and the bars list. Again, not that they wouldn't have been taken into account previously, but this now adds them into the document itself. 3 completely new categories. One is to do with alcohol misuse and dependency. The second is to do with discrimination. And the third is a section that relates specifically to non-criminal behaviours, where they may cause concern or be a cause of concern in regarding someone's suitability to hold or retain a licence. The first two do have time frames, again, time scales from when that behaviour or that conviction took place, and then when we may consider them to be suitable. The same as every other section within that chapter. Then a few amendments. This is the main one where it's been amended in terms of motoring offence, and that was the real focus. But what came out of the consultation a couple of years ago. The main one being, again, as you'll know, if a taxi driver from a taxi trade accrues 7 or more penalty points on their DVA licence, we currently state as a 5-year period before we would consider them to be suitable for the licence, which is in line with all of the other categories. Time frame is different, but that's how they deal with it. In the proposed guidance, they've moved away from that and suggested that where someone accrues 7 or more points, they should undertake a driving assessment. As long as they don't have 8 minor infringements, then that should be suitable. It also states that even if they don't pass that test, then it should only be 12 months where the person is remain conviction free. Now, we don't necessarily agree with 12-month period, we think that's too short. We also don't really know where this driving test is going to come from. The only one we're aware of where there are these sort of minor and major infringements is the driving test if you want to get the driving licence in the first place, or when you need to take a driver assessment after a medical condition or beyond a certain age. So we're not aware of a formal driving assessment that actually meets this criteria. It's not to say there aren't any out there, we just don't know what they are. The second part of the motoring offence that's been changed and been added in this time, it's now includes a section on what happens if someone gets a totting number of DVLA points and disqualified from driving. That wasn't there previously. It was one of the points that we raised when we submitted our informal consultation response 2 years ago. So it's nice to see that that's been added in. In terms of extra comments, similar to the one above, there's clarification sought on the NR3F register and reference to that being mandatory in England because it is, and it seems to suggest it's not. Again, the reference to overseas criminal checks and when they should be undertaken and how, what time period, the time frame should be for that. And then there's there isn't a category for terrorism offences. I have spoken to both who came to our training last week, who's on the working group and chaired the working group, so I was at some things even that last week, and that is going to be rectified. That will be included, respective consultation responses, and so that is looking like it will be in whatever the iteration is when we do publish this document. You can see the full list of the comments in document appendix B. So again, the recommendation for tonight is for members to note the contents of the report and agree that the document appendix B is sent in prior to the closing date of the 30th of September. If you have any questions, I'll be happy to take them. Thank you, Chair.
Any councillors have any questions or comments that they'd like to make? I just have one comment. I think it's important when they talk about infringement of a minor offence. I think the definitions have to be very clear. So I don't know whether they're going to put a glossary of terms and do definitions with the report.
In terms of chapter 4, the only place where they seek to differentiate between minor and major motoring offences. And when it's major offences, they list particular types of offence that would be deemed to be major. Anything else, therefore, by default, considered to be minor. So that's the way it's been structured previously. That's the way they've continued to structure. So an example of a major traffic offence currently is insurance involves. So an offence that includes something to do with insurance, or where something has been damaged or someone has been injured because of the driving offence. Telephone, using a handheld telephone device of some sort also passes a major offence. So there's similar type of offences where you look at the points of what can be given for those offences, you also can get points for a big fine. So the minor ones, although you may not think of them as minor, obviously depend on circumstances, but if they don't fit into the major category, then they're by default they're minor. And then we look at how many points for those.
Just one more comment, the appendix, the guidance on recording decisions that's on page 49, I think incredibly helpful for anybody who's making those decisions as part of the committee or chairing it. Very clear.
You know,
I just think that's really clear. Right.
yes, so that specifically relates to the National Register for refusal, revocations and suspensions. It came to members in 2022 with the legislation change which made that register mandatory, and there's certain things that we have to put on there. But yes, this is the helpful sort of guide pro forma as to how we should record that and what we should be doing. We don't lay it out like this, but we do have the reasoning behind and the statutory guidance that tells us how we need to record and what we record, what information goes on there. So we do follow that.
Thank you. Does anybody else have any comments to make? So the recommendation is that the contents of the report are noted and the offer of proposed consultation will be sent to government prior to the closing date. We have a proposer. Councillor Brown, second. Okay, Councillor Dillon, thank you. Everybody okay? Yeah. Thank you. We now move to the next item on the agenda, which is the taxi appeals update. Thank you, Matt.
Thank you, Chair. It's been a little while since we've been able to send one of these to you. Unfortunately, not a lot is actually going through the ports at the moment. We do get to court quite often and get told there's not enough time for the priority cases, unfortunately. But one has finally gone through, been finalised, so it would be worth bringing it to your attention. And also, as you can see, the current state of play in terms of where we are on our appeals. So, since the 12th of March, the last time we reported this to you, we've been involved in 7 appeals. 4 of the matters were just adjourned to future dates. 2 were adjourned, as I say, on the day. We were there, present, ready to go. The court wasn't able to hear due to lack of time. The other 2 were adjourned in advance for hearing dates. One was to allow a criminal trial involving our appellant to be concluded, because it was agreed on both sides that it would be beneficial to know the outcome of that trial before the appeal was heard. That would be reason the right to be taken away. And second was that the court needed the time for a case to be present. So again, that matter didn't get heard, but realistically for later on. 2 of the remaining appeals were withdrawn by the appellant prior to the hearing has taken place. The first one of these was withdrawn well in advance of the hearing, which understands that the appellant already had, or they had obtained a licence from somewhere else. So it wasn't within their interest to continue their appeal. And at that stage, they were withdrawing for us, and we had their licences returned. So they may not still be driving, but not licensed by Newcastle Borough.
Can I just ask a question? I was getting asked. No, he's done that, and he hasn't got a licence in Newcastle, so he can't come into Newcastle at all now. Oh, so.
Unfortunately, you can, because drivers, vehicles, operators are not limited by specifically the area that you work in. Any other type of vehicle they use, there's 2 different activities they can undertake. wherever they are. But they can cross border, they can do pre-work work or private hire work, depending on so what they drive. So no, you can still drive within Newcastle, but it's not licensed by us.
Thank you very much.
I think the game councillor Williams is called get your licence, lose your licence, appeal, carry on driving, change your authorities. I think that's the name of the game.
I understand that, it's just.
Or am I being cynical?
No, I think there's a couple of things there. Firstly, that's one of the reasons why the NR3S was brought in, so that if a decision has been taken to revoke or refuse or suspend, then go and register. Every local authority then is duty bound, statutory bound, but they have to check this register before they issue a licence to anyone, either as a new or a renewal. So unless they already held a licence prior, and I'm not sure which way around it is, if they held a licence prior, when they next renew, they would still have to check the register and would see that we have revoked this licence in this instance. And they would then have a duty to contact us and ask us why, and we would then give them the reasons, and then they would make their own mind up. So we can't influence their decision making, but we can tell them the reasons for it. If it is that you didn't have a licence with an authority previously, we revoked it and went got the last time under appeal. It was on the register, they would have made the check, and they would have deemed the information that we provided that person is fit and proper. The second element I was referring to is it comes back to those suitability guidelines. We use those because the idea for the IOF, and then obviously from the Department of Transport, because if all local authorities worked to a very similar set of standards, these sorts of things wouldn't happen. You wouldn't get a licence taken away in one area, go next door or to anywhere else, and then they use a different set of standards and go, yeah, actually that's fine as far as we're concerned. Can't tell you the specifics of all of these particular individuals. I don't know them, but those two elements are two tools that are sort of been looked at more widely to try and stop this sort of thing from happening. It does still happen, not as much as it used to, but even if someone does have a decision taken against them, and even if they do have the same guidelines somewhere else, for example, they may still come to a different decision as to what we did. So it's a tricky one, but we can be sort of safe in knowledge that they won't be driving a Newcastle handy carriage, they won't be driving a Newcastle private hire vehicle, they won't be working for the Newcastle private hire operator, but for the local authority licensed operators, which are can crisscross Newcastle, Stoke, and behaviour.
Thanks for that.
No problem.
I mean, heaven forbid that something should happen to someone. But if we've said no to a licence and they're on appeal, and they've gone somewhere asking about a licence because someone isn't as thorough as we are, and something happens to that person, then there's a culpability for the other licensing authority that's allowing a taxi cab's licence. The culpability just raises, and they could be involved as a party to something dreadful.
I did realise actually.
Yeah. I'm just doing it for the record. Councillor Parker.
Thank you, Chair. I'd just like to say congratulations on the £3,316 that you've received from these appeals. A little does go a long way. Well done.
Yeah.
Thank you, Councillor. Yes, you've got ahead of me. So the jury was the second one, which was part of the 3,300. That was, we were there on the day. They wanted to fight their cause. Sort of persuaded them it wasn't really in their best interest to do so, because our full cost would have been about £2,500. And they reluctantly withdrew their appeal, and the court ordered to pay some of that money. So something better than nothing. And it goes some way to pay our legal costs. But yes, the matter at 2.4 is sort of big news, if you like. We had an appeal that's finally been finished, done. It's only been going on since July 2020. The appellant can turn up. No explanation why. Sorry, I was a bit flippant about that. They didn't turn up, so we requested that the appeal be dismissed in their absence, which was agreed. Our costs were 2,816, as you can see. They were fully awarded to us. We're in the process now of recovering those funds from that individual. The reason being gone on from 2020 was a decision was made at the start of the pandemic. And there were 2 or 3 times where the individual wasn't in the country and wasn't able to actually get back to the country. But there have been some occasions where we've been sat in the courtroom and ready to go those sorts time. So that's the state of the courts, certainly around here. And then finally, as it stands, we have, it says 9 outstanding appeals, which was just another one today. We have 10 outstanding appeals, the magistrates' court, and none progressed to the Crown Court. Thankfully. Happy to take any questions if there are any.
Any councillors have any questions or comments? What a quiet night. Okay, if we move to part 2 of the closed agenda, you'll be absolutely delighted at 7:29 to hear that there are no items to be considered on the closed agenda, so we can move to item 8. We'll be even more delighted to hear that there are no urgent items for item 8, so I can declare the meeting closed at 7:27. Thank you very much for attending.
Thank you.
Thank you.